Hello and welcome to Commercial Contract Drafting Essentials, 6 modules to avoid litigation. Today we're going to look at the first of those modules on the topic of the battle of the forms. As always, let's begin by having a look at the agenda for this session. So we're going to start by talking about the issue of incorporation of terms. So obviously we can have significant argument between two parties as to whose terms and conditions apply. And when we're thinking about whether terms have been incorporated, there are two methods that we'll look at. So incorporation by signature and incorporation by notice. And we'll look at the various requirements with regard to that. Now, linked with the issue of incorporation of terms, we then have the issue of entire agreement clauses. So something that hopefully is familiar to you, but we're going to have a look at some examples of those. We'll see how we use that to potentially resolve disputes about whose terms and conditions apply. And we'll also see there's another angle towards the end of the session today where this particular clause can be useful, where we have some form of initial agreement that then is overtaken by a later agreement. And we'll see what entire agreement provisions have to say about that. Of course, the title of the session today is indeed the Battle of the Forms. And having looked at a bit of background on incorporation of terms and entire agreement, we'll move on to the Battle of the Forms. What does it mean? How do we resolve it? And we'll look at a series of case studies with regard to that. So 3 of those in total, which hopefully you'll find interesting. So that's the agenda. Let's start straight away then by looking at the issue of incorporation of terms. So the key thing to note is, let's just recall that to form a contract in English law, we don't need to have anything in writing, strictly speaking, and we don't need to have a signature either. However, of course, it makes perfect sense to have both something in writing and potentially a signature, because that makes it easier for us to establish which terms and conditions govern the relationship. And in particular, if we're looking to be able to argue successfully that we've incorporated terms, the easiest way to do it is to do it by, under the general rule, it's what we call incorporation by signature. Now, that's not exactly rocket science. Essentially, it's the process whereby we have a draft going backwards and forwards between two parties. We negotiate over that draft. Obviously, the document has a place for both parties to sign. And once the negotiations are concluded, both parties do indeed sign. And that effectively means that we've incorporated those terms by signature.